Hi everyone, my name is Miranda Dressler and I'm an attorney with the law offices of Bridget Mackay in Petaluma, California. And we practice in the areas of estate planning, administration, and elder law. And today I'm going to talk to you about the question I often get which is, if I have a will, do I need a trust? And so the answer to that question really is, it depends. It depends on your assets and kind of how you want to leave things ultimately for your family or for your loved ones after you pass away. And so a will and a trust are different estate planning tools, but they often are used together. And so a will, when it's with a trust, has a very different role than a will on its own. So if you have just a will as your main estate planning document, this is going to be the document where you name an executor, who's the person who handles the administration of your estate when you pass away, and you name who your beneficiaries are, how they receive their inheritance, and if you have minor children, you would name physical guardians for them. If you have a trust, you also will have a will generally that will kind of go along with that trust, but it has a very different role. In that setting, it's called a pour-over will. And the purpose of a pour-over will really is to cover any assets that may have been left out of your trust, usually by accident. And then those assets, after you pass away, would have to go through the court process called probate, but they would be put back into your trust at the end of that process. Also, in a pour-over will, you name an executor, and it's also the place where you would name physical guardians for your children. If you have a trust as your main estate planning document, a trust covers you while you are alive and after you pass away. So a trust is where you would name a successor trustee who would step in to manage the assets in the trust in case you become incapacitated at some point, and then to distribute those assets after you pass away. And then the trust is also then the place where you would name who your beneficiaries are and how they receive their inheritance. For example, often sub-trusts are created for the beneficiaries that continue on after you've passed away and protect the inheritance for those beneficiaries. And so the answer to the question of, if I have a will, do I need a trust, is, what we generally say is if you own real property, or you own assets that total more than around $166,000, then most people in that situation would prefer to have a trust as their main estate planning document. If you just have a will as your main document, a will has to go through probate when you die, and a will doesn't do anything for you if you become incapacitated at some point in your life. A will only comes into operation when you die. So thanks for listening. If you have any questions about this or any other estate planning topic, you should contact an experienced estate planning attorney in your area. Thank you.